some covering your assets.
Yes. Hey, everyone. I'm Renee Butler. All right, here we go. Wait for a few people to join. Eric has gone live on my session as well. So I wanted to welcome everybody to Live with Renee. I am the Life Over Coach, and every Sunday I go live at 7 o'clock for about 25 minutes, and I give you guys free business advice and tips and tools to help you manage your business. So we're giving it a few minutes for everyone to join. We will start at 7. If this is your first time, do me a favor and tell me your name, where you're from, and why you joined. And today we are going to be talking about covering your assets. So we want to make sure that everyone's protected in their business lives and their personal lives. And Eric has agreed to do this for us for free. So I told everyone for the price of free $99. You guys, hopefully you took some time to jot down all of your questions because it's not very often that you get this rare opportunity to get some free legal advice as well as free business advice. So I tell all of my followers, every Sunday, you guys think of every question that you have and you bring it to me because I give you advice for free. If you call me after we end this session, we have to charge you, unfortunately. So welcome, everybody. I'm really excited today. We've got Erick Tyrone here of Tyrone Law Group. Tyrone is live. I'm live on Facebook and Instagram. I wish you guys could see this crazy setup we got going on, but we're here. We're going to do it. We're going to make it work and have a good time tonight. So if you have questions, type your questions in. I will get to them. Oniki said Erick's head is glistening. It is. Yes, David, he is one of the smartest attorneys in the area.
That's what it is. Don't mind me. You can get on the fresh shade.
So those of you on Erick's phone, if you could put like a star or something to let me know you have a question and it's just not a comment, that would be great. So that way, because I'm trying to keep up with 3 different devices. So bear with me. We will get everyone's questions before we end this session. I'm allocating a whole hour tonight. Usually we only go live for about 25 minutes, but you guys got us for a whole hour. So take advantage.
She don't want me to make no money.
I do. Hopefully this session is going to teach you guys a lot about if you don't have your proper things in place, either business or personal, you're going to learn a couple of things. So we are going to get started. Thank you, everyone, for joining. I see everyone over here on Facebook has joined. Thank you, guys. I don't see any questions. But again, tell us where you're from. And then you guys, as we go through, you can start typing your questions. AJ said, hey. All right. So we're going to start off. So from a business, I'll just talk for a quick second. I'll let Erick talk. From a business perspective, as a business owner, I think it's very important to make sure legally you have all the right documents and things in place to operate your business. And I wholeheartedly believe that if you have a business, you should have an attorney on hand that you can refer to, talk to, go over documents with, and have them review every piece of legal document that you create or craft, including all of your agreements that you have with other people, as well as how you operate your business, as well as issues or things that you may have with your employees that you're creating to protect yourself. All right, so I'm going to turn it over to Erick for a second so he can introduce himself. Now we've got like 1, 2, 3, 4. We have 5 devices up, guys. So
hey, everybody.
It's like a little studio in here.
My name is Erick Tyrone. I am an attorney here in Maryland. I practice primarily estate planning and personal injury, but I also do some general litigation, and it feeds into business and contractual law. And so we're here today. The idea was as Renee was asking me some questions about, some questions that she's received from her followers, saying, here there are a lot of different business-related questions and questions as it pertains to the law. And she says, hey, would you like to come on and have a conversation? And so, yes, absolutely. I'd love to come on and start asking questions. For me, the social media is where I fail at life. Okay, so I am just now trying to get caught on and have some type of a social media presence. So besides just saying hello and commenting on people's pics and stuff. So I think the idea is, I'm going to try to see if I can, build some type of a social media presence here and be able to answer questions, ask questions. And so if you've got them, here's the time to, to chime in and ask and see if we can get them answered.
Awesome. So I'm going to do kind of like a Q&A. I'll ask you some questions. And guys, if you have questions about what we're talking about, just type them in, whether you're on Instagram or his Facebook or my Facebook, and we'll get to your question before we move to the next one. Oh, would you say bring the camera? If you guys could see, I have this Jimmy rigged. You'd understand why it's kind of like this. All right.
Pink. I'm surrounded by pink.
Pink is good.
Everywhere.
Pink is great. All right.
I love pink.
So let's start off, since every week I go live and I talk about business matters. What does a business owner need to protect themselves and their business?
Well, I guess that's kind of a loaded question. I think, are you saying protect themselves from lawsuits, liability, taxes, contracts? I mean, there's a lot of different things that a business person could be, that a business person could be. So kind of narrow it down just a little bit for me.
Yes, I think, what would they need? Like all of that. So could we go through like lawsuits, liabilities, each of those like one at a time? Sure. Okay, so let's do that.
So as it pertains to lawsuits and liability, I think the biggest thing is that you want to make sure that you are incorporated. You want to make sure that you have the appropriate documents so that you're not personally responsible for the different decisions that are made, that the business makes. For example, if you are, if you own a restaurant, you don't want if somebody gets sick at that restaurant, you don't want them to be able to personally come after you and force you to sell your home in order to get recompense for their injury. And so you want to make sure that the only thing that is liable, that has responsibility, is the actual business. And so if the business makes a poor decision or makes a mistake, then fine, the business should suffer, but it shouldn't be you personally having to, relocate and move because of said decision. So as it pertains to lawsuits and liabilities, you want to make sure that you properly incorporate, that you want to pay the appropriate fees throughout your state. Here in Maryland, every year is a $300 fee to make sure that your business is properly incorporated. And so you want to make sure that you stay up on those fees and continue to keep track of your licensing.
Okay. So let's see, Edison Vaughn has a question. He says, what are the incentives for, sorry, I just have to move this a little bit, for forming a LLP versus being incorporated or even a professional association?
The benefits, well, every state doesn't recognize LLP. Maryland doesn't recognize limited liability partnership as opposed to limited liability corporation, but some states actually require them. So if you are a professional and you have a professional license, it is important that you have the appropriate ownership and the appropriate titling of your business to make sure that you have that the professionalism remains intact. So I hope I was able to answer your question. What are the incentives for forming an LLP? I think that deals with I'm not sure where you see, I know he's up in Minnesota, And so Brandon up in Minnesota, he may have something different with the LLP than I do here in Maryland with the LLC, because we don't actually recognize that as a business entity here in Maryland.
Okay. So Brandon, you may want to hit him offline, and I promise you that question he'll answer for you for free. Since you brought it up here, because he may need to look up your state's tax laws. All right, so Andrea says, hey Eric, I have a food business and currently work in a communal kitchen. I have volunteers that help me with my baking. I just recently saw her with a copy of my request, though I don't think she's trying to take advantage. Or should that say recipes? Recipes, yeah. Oh, recipes, I'm sorry. Though I don't think she's trying to take advantage. I'm looking to protect myself with an NDA. How formal does an NDA have to be?
Well, I think you want it to be very formal. I think you want to explicitly disclose what it is that they are allowed to do and what they're not allowed to do. And I think you want to make sure that you have that you appropriately limit somebody's ability to act on the information that they receive from your business. The biggest thing is you don't want somebody to, it's all fun and games until there's a problem. And when there is a problem, you want to be able to go back to that document and say, look, you were not able to go out and use my recipe and go open up your own cookbook because, my mac and cheese is better than your mac and cheese. And now you've opened up your own cookbook based on that. And so you want to make sure that it's actually very, that it gives you the appropriate power, that any information that they receive while an employee or receive on behalf of the relationship that they have with you, that is not going to be something that they can share with somebody else or profit or benefit from there. That's really important.
And AJ, we talked a little bit about that last week. I think Tangela brought up the question of she's got recipes, and we talked about always having an NDA in place. That also goes for if, let's say, someone's starting up a business, Eric, and they're just talking to someone, you should have an NDA in place. If you are just in the startup phase and you're trying to go through ideas and talk with someone about something, just to protect yourself so they don't take your business idea and run with it and go and patent everything and start their business. That happens more often than people think. So just make sure you're always protected. I keep an NDA on my phone in case someone wants to either talk to me about something or I'm talking to someone about something. I can send them a digital NDA and they can sign it there. All right. Did we finish we've got taxes. So those were lawsuits, liabilities. Okay, let's go to taxes. Let me just check to see if there are more questions. Someone says on Instagram they can't hear us. Sorry, guys, you fell. That's my hand. Sorry. How about I wonder if I can just hold your phone. Okay. Hold on a sec. We're going to figure out how to make this work so that we got you guys here. We're going to just lean it up. Sorry, guys. Hold on a sec. Can we do it sideways?
You can't turn your phone.
Oh, you can't turn it long? Okay. Let's see. All right. Here we go. I think we're good now, guys. Sorry about that. All right. Now I can see everybody's phones. All right. The other question, Ivan says, I have a delinquent, hold on, Ivan, it's scrolling out. I have a delinquent client that hasn't paid. What are the proper steps before filing a small claims court?
First, you just want to make sure that you put them on notice that they've, I'm sure they know they haven't paid, but you want to cover your tracks and cover your case. So you want to dot your I's and cross your T's and make sure that they know that not only do they owe you, but you want to explicitly detail what they owe you, such that you can go back and you can go to one place and actually find everything. And so if they owe you, and then you want to start marking and noting your fees, noting your receipts, making sure you're keeping track of everything, because getting paid on your contract for your work is really important.
Okay, guys on Instagram, can you hear us now? I turned up the volume. All right, Ivan also had the question going back to An LLP, it's just proper entities for desired occupation. I was just talking to a client right before we went live about she's starting a new business and she was going to set up just a sole proprietorship. If you just have one company, my preference is an S corp, because with S corporations you're not double taxed. So as an owner, let's say you wanted to take out money, your company with a regular C corp, your company pays taxes on all of the money that you earn, and then you, as a, let's say, employer, owner of the company, then pays taxes on what you get. So you're taxed twice. So look into, if you're not familiar with how to set up an S corp or how it works, talk to a tax attorney or your accountant, and they can go through all of your options with you. All right. Ivan said, I need my money. You don't want my money. All right, Ivan. Okay, so let's go over. I think I got all of the, let's see, any more questions over here? Follow-up question. Can it be retroactive? Yes, AJ, you can do your NDA, and because those are recipes that you're always using in your business, it will apply immediately.
But you're going to want to make sure that there is some type of consideration for that. But basically saying, if that means that you have an employee that is choosing, maybe they're getting paid right now, and you go into the relationship thinking that because you're getting paid, you should be obligated to whatever terms you previously agreed to. You do have to be mindful that there's in the law, past consideration is no consideration, and so if you don't, if you're asking for a non-disclosure to be pertinent to past information that they've received, you may have to compensate them for that. For the agreement, and basically say that there is something that's been put on top, because if it won't, it may not be, it may be challengeable if you don't. Okay, so as it pertains also to taxes and contracts, when you're dealing with taxes, I do suggest that you speak to not only a tax attorney or an accountant, because it changes so much. You should not rely on your own information or your own understanding of the tax code. You really want to make sure that you're reaching out to people that do this on a daily basis, because they have ways of understanding the issues better than our own lay understanding. One thing that I definitely do is I speak to a tax attorney about my issues, because even though I have a small understanding of taxes, when it really comes to important tax issues, I don't try to depend on myself. Make sure you reach out to somebody, a professional, because it's always better to speak to a professional. And even if that means you have to pay a bit of money to be able to get that professional advice, you don't want to end up. Sometimes you can't afford not to pay for that advice, because it really can, guide you in the right direction.
Absolutely, I totally agree. And I mean, I've shared pretty much in terms of contracts. I've shared with you guys my situation where I'd been sued before, and there was no way I could have represented myself and won that case. What are you doing?
I was just trying to make sure I could see the question.
Okay. Oh, I got him right here.
Oh, you got him.
Yep, I got him. All right. So Ivan said it would really need to be how much money did the company would be looking to make per year if it's going to be financially free, something for you to do anything corp as far as S or C. Ivan, go back and fix your typos so I can reread that so I understand what's going on. All right. So then the next question is, in terms of protecting yourself, or I guess when you die, like, what do you recommend for people?
Okay. Well, I mean, I don't think there's a one size fits all. I think people want to hear that, all right, if you have this, you're going to be taken care of. Some people say if you have a will, you're going to be taken care of, or if you have a trust, you're going to be taken care of. Well, I don't believe it's a one size fits all. Everybody's situation is different, and the more I see, and the more trusts, wills, and other documents that I create, I understand that literally everybody is different. So I think there are some things that everybody should be concerned with. But I think I kind of use a general plan for understanding, and I don't mean to jump ahead of the notes that we have, but just kind of understanding what it is to have a proper estate plan, or what it is to be, what I look to understanding what it is that is appropriate, what people need, what people want, and what is the wishes that the person that I'm dealing with, what is that they are actually needing. Because if you talk about, yourself, you have one daughter. Well, somebody that does not have a daughter is going to have a different set of circumstances than you would, and that doesn't mean that you guys, even if you want the exact same things, but they're just different circumstances. Especially since your daughter, at the age that your daughter is, your daughter is done with college, but she is, somebody that has a daughter that's 4 is going to be dramatically different than yours. So every situation is different.
Okay. So from a business standpoint, what are the things that you would recommend people have in place?
Okay. Well, to protect your business, I think it really goes back to the documents, and we were talking about non-disclosure agreements, but it goes back to the documents that you created. It starts with your operating agreements. It starts with the articles of incorporation, articles of organization, depending on what type of structure that you're dealing with. Because, for example, if you, let's say you have one business partner, and that business partner is married. Well, today, when they start the business, they're married. In 10 years, that business has grown from something that's earning $40,000 a year to something that's earning $400,000 a year. And if that business partner gets divorced, now the spouse that's divorced is going to be looking at the assets of that business. And so if you don't have written out really well in your operating agreements the different types of plans that are going to be put in place for that situation, you're going to be dealing with the default instructions of your jurisdiction. And so that could put you in a bind. It could make you have to deal with a set of circumstances that you would not have agreed to in the beginning when you were organizing. So it is really important that you go and you speak to an attorney or somebody to help you plan out your steps ahead of time, so that you can actually have the conversations of all those people that have businesses. You sit back and say, where is your operating agreement? Where can you get to it? What happens if your partner if they get divorced, or what happens if you need to add another partner? Do you have in your operating instructions what happens to them? What are their voting rights, etc.? So these are a lot of different questions that you want to think about in the beginning.
So can you explain just quickly, what are the difference between articles of incorporation and articles of organization?
It's depending on what type of organization you're creating. One is for a limited liability company. One is for a corporation. And so there are similar documents. They talk about, they make sure that the default instructions that the state has for different businesses are not necessarily going to be binding upon this document. You're going to deal with the instructions as you guys have them written throughout the articles. So your particular business is going to be a little bit different than are the default, because the default isn't right for every business. And so, if you sit down and think and take the time to think about and create those documents, you want to be able to have it included such that, you get your wishes, or at least your wishes to the best of your ability.
Okay. So most companies have, and personally, we all carry some, or at least I hope, we all carry some type of insurance. For a business, are there any particular types of insurances that you would recommend?
Well, so there's, I think you want to start looking into there's key employee insurance. There's an insurance that can protect you just in case. That's the type of insurance that says if my key employee is somehow if they die or if they have a set of circumstances that want to protect, that there is there are finances to protect those interests. For example, if you have a business, and again, your partner is the one that handles all of the actual production. You go out, you go make all the money for your business, but your partner comes in, they do the work, they tighten up the work. So they are really an integral part of your business. You want them to be able to be protected. So if they leave, then you actually have, or if they pass or something else happens, you can get some type of insurance claim, such that you can protect yourself and your business from the risk of that loss. And so you're not starting day one without having any assets to protect the loss of having that employee.
Okay. So I want to move on a little bit to, I think, a little bit of estate planning and talk about personally what are the things that you should have in place. I recently had a coworker pass away, and she only left a will. But she put in the will some directives about, how she wanted her child cared for and who she wanted to care for her child, and some other things. So it's been a nightmare with her estate. So I really just want people to understand what should you have in place so that when you pass, whatever your wishes are executed in the manner that you've documented. Because one of her family members said, she's dead. It doesn't matter what she wants. We're making all the decisions now. And it broke my heart, because you think that, I've done all of this, I've put these things in place, my child will be cared for by the person that I want to care for them. And because she didn't have, all she had was a will, her directives are not happening. So what are the things that you would recommend that every individual have in place in living and dead and upon your death?
Sure. I think again, there is no perfect formula for everybody. Everybody's different. Some people, will-based planning is the appropriate avenue. For some people, trust-based planning is the appropriate avenue. And it's not a one size fits all. The fact that she had a will, and her heirs or her family members are not adhering to her wishes within the will, well, that's problematic. And what's going to happen is that you'll find out when they open up the estate that they will be responsible for those, taking care of that. I've certainly had a call this last week where I had to basically stop a parent from selling assets of their deceased child before they've opened up the estate, and before they basically they did not have the funds to be able to pay for a second mortgage. So they says, look, I have to sell this house rather quickly and sell the assets within the house. And it's like, wait, stop. The idea is you have to do it the correct way, because you can be held responsible for those decisions that you make. And so, whether you do have a will or not, you do want to make sure that you appoint the appropriate people, the people that you trust, to actually adhere to your wishes. If you wouldn't trust that person with a bag of Skittles, I wouldn't name them as your executor of your estate. If you wouldn't trust them with a box of Snickers, then I wouldn't make them your power of attorney. And if you wouldn't trust them with, to take care of you when you have a cold, I certainly wouldn't make them the healthcare director, because those decisions, they really have real ramifications. And it's always at the worst times when you find out whether that person was sufficient or not. So it does take time. It takes conversation. It takes actually opening your mouth and having difficult conversations, because just because you start talking about death or you start talking about a power of attorney does not mean that you're actually going to need one. It does just mean that you're actually having the conversation about that whole process.
Okay. Let's see, we have a question. So I'm starting a company. This is from Alex Tyler. So I'm starting a company and bringing in partners, and you put in a partnership agreement amongst us. What are the types of clauses that should be in place if, I think that may say, one decides to leave the business, or of course, as it was stated, becomes deceased?
Well, there's a lot of things to think about. You want to think about the dissolution of that business. If those partners are no longer there, who are the heirs that are going to come back and ask for their portion, their money, their rights, right? And so you want to think about that. How are those decisions made? Who makes those decisions? Where do you go to have this answered? If they decide to split, you want to start talking about what happens in the event of a split, and you want to really start thinking about 2 and 3 steps down the road of the decision to split. It's not just the day we decide to split, because you may have proceeds that last for a year, that lasts for 2 years. You may have to be bought out, and so there's when you're starting to look at dissolving a company, you really do want to take the time to get somebody that's actually done it, that's been able to read, that may have a document that you can look at as a template, so that you can start having the conversations and address those different issues and see, based on your current circumstances, how would that affect you and and your business partners. And so I guess the question is, what are the type of clauses that should be in there? Well, every case is going to be different. I mean, I think that unfortunately, it depends is going to be a real, it's going to be an answer that's going to be prevalent to a lot of these different questions, because it is going to depend on your particular circumstances, because Renee's business is different than my business, and so we're going to have the same clauses would not work for both of us, so we do have to be mindful of that.
Okay. So what are in terms of estate planning, what are the things that you would say people should think about?
Okay. Well, I mean, I think the biggest thing is you to learn what is a good, sound, or proper estate plan. You want to think about at least 5 entities. When I give seminars, I talk about 5 entities of a sound estate plan. The first 4 are dealing with the transfer of your own property, your own assets, you being able to control those things, right? And so you want to be able to give what you want. That's number 1. What you want, to who you want, when you want, and how you want. If you can control those 4 entities, you giving what you want, to who you want, when you want, how you want, you at least get to control what it is that you're transferring. If your estate plan can knock out those 4 things, then you at least are giving the proper dissemination of your assets. The last thing is you want to be able to control your incapacity. You want to be able to control what happens to your finances if you are unable to make your own financial decisions. What happens to your health if you are unable to make your healthcare decisions? And so if you can address all 5 of these different elements, then I think you're on your way to having a sound a sound estate plan. If you cannot, for example, if you have a 4-year-old child, we talked about this just a bit earlier. If you have a 4-year-old child and you have a will, and you say, all right, I've got 2 life insurance policies, I have $1 million, and I want to be able to leave this to my son or daughter that's 4 years old. Well, you're not actually doing a great job for will-based planning because you can't give a 4-year-old $1 million. And when you're dealing with this, now you're just inviting the state to come in and take part of this, because now the state is going to have to make sure that they have some type of conservator, right? And so when you sit back, people say, some people are married and have a great relationship with their child's with the other parent, but some people don't. And so when you sit back and you say, all right, if I don't have a great relationship with my child's parent, do my wishes that I have in my will, naming of a guardian, is that actually going to take place? Or do I, or are my wishes actually going to happen? Can I actually transfer the assets that I want to transfer? Like you said, if you got a 4-year-old, you can't give a 4-year-old $1 million no matter what you did. So you did a great job of planning, and you did a great job of creating assets and being able to take care of your heirs. But because you did not actually accomplish those 5, of the 5 tasks, giving what you want to who you want, when you want to give it to them, and how you want to give it to them, you don't have a proper estate plan. So will-based planning is not necessarily the best planning in that circumstance. You want to deal with, trust-based planning such that you can actually have somebody that's responsible, that's able to take care of the needs of the child that you have. So, that again, is not a one-size-fits-all for every circumstance, every situation.
Okay. So what are the costs for these types of services? Are they like, well, we know most attorneys are hourly, but do people offer like package services, or where you can buy like a whole estate planning
kit
bundle? Yeah.
Yeah. Well, I mean, and again, my favorite answer is going to be it depends. It depends on the location where you are. Here in Maryland, I say, I just give, an example. If you're dealing with, different ranges, you talk about somebody doing will-based planning, we're talking about somewhere between $1,000 and $1,500 seems to be the going rate. So they're kind of in the ballpark when they're talking about those prices. But then you're talking about, that's a will, a healthcare directive, power of attorney, different cards that you can get, and making sure that you actually have the appropriate funding for that. And I mean funding as to say that make sure that your powers of attorney are actually effective, because even the best, most nicely written power of attorney is only as good as the paper that it's on, because every business does not actually accept it. For example, if you have a great power of attorney, it's been written, wonderfully, but you go to, insert bank's name, for example, would just use Bank of America, because they're a really big bank. You go to Bank of America with that power of attorney, they may say, no, we're not going to accept that power of attorney because it's not on our letterhead. So we need you to have, to come in with that person to be able to sign on their own letterhead to say this is the appropriate power of attorney. Well, sometimes when you go to inform them, you say, hey, listen, my mother's in the hospital, she's got dementia or something like that. I need to be able to, here's the power of attorney. I need to be able to serve as the power of attorney. And now they say no. Now is when they say no, you can't do what it is that you want to do. That power of attorney is not sufficient because it's not on our letterhead. Now you've already told them, look, she no longer has the mental capacity to make this decision. And so now they're going to say, oh, I'm going to put a freeze on this and say that nobody's touching any of these assets, and basically you've just frozen yourself out. So you don't find out about the deficiency of your plan until sometimes it's too late. And so if you get somebody that actually will help you to work with the different banking institutions for that same fee, then that's actually a better deal, because they will make sure that at least the documents that they create are accurate and are sound. They can actually do what you want them to do, because that's really important.
So you said something that I didn't know. And I think we all think when we are putting things together and you have it notarized, you're saying that some banks, if you have a power of attorney written, will not take a power of attorney that is not on their letterhead.
Absolutely.
Oh my gosh, guys, that right there was worth this whole session, because I had no idea. So does that mean if you've got, you got accounts, let's say a couple credit unions, Bank of America, PNC, that you should have a power of attorney for each one of those banks on their letterhead?
Well, basically, you want to be able to go into the bank and say that if your idea, all right, for example, you have one daughter, and your daughter is now of the age of majority, and you feel confident that, number one, she's not going to take your money and do something, nefarious with it. You say, if something happens to me and my daughter comes in here, I want her to be able to serve as my power of attorney as it pertains to this bank. So you go to your Bank of America and say, Bank of America, I would like to sign a springing power of attorney so that my daughter can come in and, if something happens to me, if she says she's got these notifications from doctors saying that they don't have this mental capacity, we need to be able to make this happen. So you go to Bank of America and do that. Then you go to some different federal, your federal, maybe federal credit union, and you go to your, local university's credit union. I went to Wisconsin, so the University of Wisconsin Federal Credit Union, or University of Wisconsin Credit Union. So you go to those different banks and you sign, the powers of attorney on their documents, and that's a contract that they have entered with you now to be able to do as your wishes suggest. But that also goes back to when you're dealing with trust-based planning. Well, we also kind of are doing the exact same thing. When you're dealing with trust-based planning, you make sure that your trust is funded. And so I'll get back to what that means to be funded, but basically you leave the law of intestacy, or you leave that law, and you start going into contract law, right? And so what that means is, if let's just say you go to Home Depot, right, or Lowe's, you go to your that type of store, the home improvement store, and you go get that Build-A-Box, right? You go, so you're going to get a big box. You're going to get some wood, nails, screws, whatever it is, and a set of instructions, okay? And so that set of instructions is going to teach you how to build that box, okay? And so you go home, you use all the tools, you create your box, and you've now got your box in a corner. And if you set your instructions right on top of that box, what you've done is you've bought yourself a box, and a box with instructions. And if you don't put anything inside that box, all you've done is created a box. You bought a box, right? Mm-hmm. The idea is, in order for that box to mean something, to have some type of value, you have to put something inside that box. And that's what I'm talking about when we're saying funding your trust, right? So if you're saying if a trust is going to be the exact same thing, it's not one document, it's 10, 12, 15 documents based on your own circumstances. But we say, but it's going to be a binder. It's going to be a set of instructions that's going to create a box. It's going to create a trust. And so if you don't put anything inside that box, all you've done is bought a nice, big, expensive box, right? It's going to be, you haven't done anything. So funding your trust is you actually putting your assets into that box and retitling your assets such that now your assets are, you've actually created something. Something's in the box, like your house. You've retitled your house. You've created the deeds to retitle your house such that your house is now inside that box. Your bank accounts, you have gone to those different banking institutions such that they now send you your statements saying, instead of Erick Tyrone, now Erick Tyrone, trustee of the Erick Tyrone Trust. That's now the new name. I've retitled those documents. I, Erick Tyrone, no longer own the assets of that bank account. I, Erick Tyrone, own I am just a trustee, right? And me as the trustee, I am the one that's responsible for those assets. But now that box, what's in the box owns those different assets. And that's kind of how you start. When you fund that trust with that credit union or the Bank of America account, now you are going into the laws of contracts with them and saying, all right, I agree. They are agreeing that you have this trust. The terms of this trust, they are signing off and saying they abide by the terms of that trust, which means if something happens to you, and you go to them with your power of attorney and say, Bank of America or, Navy Federal, here's the power of attorney. My mother, she's got dementia now, and, she can't make her own decisions. Well, now of course, they're always going to say no, because I think they're trained and predisposed to say no first. Like all banks just say no for whatever reason. So once they say no, and they say, no, you can't do this, and you go and you say, wait, that's not true, because you have a contractual relationship. You have entered into a contractual relationship, because here's the trust. You've now agreed to, because you're writing in this thing that I'm the trustee of this trust. And so the terms of this trust are pertinent. And so inside this trust, I've got notifications that say, I, Erick Tyrone, if something happens to me, I'm naming my son or my daughter, or I'm naming this person to serve as my power of attorney. And if they have agreed to this, the terms of this contract, they've agreed to what's written in this contract. And so that's kind of how that trust planning works. So it was a very long way of getting around saying when, the funding of a trust is an important piece to add to how much the trust costs. So if you go and, around this area in Maryland, you're going to deal with something around $2,000 to $2,500 just to create the trust. But if you actually got to put your funding into the trust, I mean, by the time you're done, you're probably looking somewhere between $4,000 and $4,500 to put your life in the trust to make sure that those things are done properly. Because if not, all you've done is, again, created just a big expensive box. All right, so it's important to go through and actually have somebody actually fund the trust properly, because it's not an easy thing to do. So that's a long way of saying these are some ballparks for here in Maryland, but every jurisdiction is different. If you're in Nebraska, I expect that it's going to be different than it is out here in Maryland.
So you brought up something good that I wanted to ask you about. So you've got, let's say you have all your assets in this box in this trust. If someone sues, let's say Tyrone, Erick Tyrone, is that trust protected, or can they have access to that trust if you get sued? And let's say they win.
All right, so can they get a judgment? All right, so when they get a judgment against me, Erick Tyrone, now they're saying, are my assets that are in this trust, are they protected from judgment? Again, the short answer is it depends. It's going to depend on how it's written. The idea is if I have, if inside, think about that trust, you got that box. If I, Erick Tyrone, can reach inside that box and take things out and have the control to do whatever I want without somebody else's supervision, the short answer is sometimes a creditor can also go and have access to those accounts. It's not always, but they have better access. If I individually cannot reach in there and take assets out, then it is more difficult for that creditor to be able to attach and consume those assets.
Okay. All right. So those were the last of the questions that I had written down that I wanted to ask you. So guys, I'm going to give you guys a chance to type in your questions. I know that there's a delay, and I'll let Erick. I wanted you to talk about too. Erick is also, I don't even know if it's the right term, an authorized sports agent with the NFL. Is that the right terminology? Okay. So I just wanted you to talk about that a little bit.
Absolutely.
Okay. So people, if they want to reach out to you, they can find you. I think we got all the questions. Just wanted to scan through, but I think we did. I'm just checking Instagram real quick. I think we got all the questions here. So you can talk about that for a minute and then tell people where they can reach you.
Sure. I am a contract advisor with the NFL. And so if you know somebody, if you know Reggie Bush or the next Reggie Bush, give me a call, because I would love to represent Reggie Bush or the next Reggie Bush. I promise I'll do a very good job of doing it. So my website is the TyroneLawGroup.com. The phone number is 301-358-6664. Email address is Tyrone@TyroneLawGroup.com. So that's different ways to reach me. You can, I know I'm on Facebook and Instagram, and I even think I got a Twitter account, but I can't tell you how. I don't know what the Twitters mean. It is all bad about how to get to the Twitters. I will have my staff try to help me get on the Twitters, because I don't understand it. I just got the Instagram because I can take a picture and load it. It's bad over here.
Social media is a big deal.
It is a big deal.
By the way, my company also does social media management. So,
I might have to put $2 on it to have you, say something to somebody. At least give me a tutorial or something. It's like there's an indirect relationship between the amount of informational technology that I can put in my brain compared to the law. The more law I get, I used to be on it. Now I can't look. I don't even pretend to be on it anymore. So it is what it is.
It's a doozy, and there's so many platforms out here now, and so many people on each one of the platforms. But parting words, I don't see. Let me just make sure. if there are any more questions. I don't see any.
Okay. Well, let's talk about one. One thing that has actually come up this week is, what do I do first? Right.
That's a good one.
So if I did talk about, I had a mother who lost her adult daughter.
Mm-hmm.
Her daughter had a mortgage. She had, she has, a house and stuff. She wasn't, these weren't children. And the question that came to me was, I don't even know what to do first. Am I now responsible for her assets? Am I the one that's is somebody going to come out? Do I have to pay that mortgage? So people wanted to know that. What do I do first? Well, I'd say the first thing is handle all burial instructions. Deal with that first. Okay. Do your mourning thing first. I would look for life insurance, right? If she has maybe something she has with a job, because it's not always easy to come out of pocket to be able to put somebody in the grave. So I would look for that. That's really the only thing that I would do immediately. And then after that, start watching the mail that comes in, because the mail that comes in is going to start being able to tell you what the assets were of the person. Everybody sends a statement. Now, understand it. Here's the new kicker that I am starting to deal with, and that my clients are starting to deal with. You start to see what happens if the mail, that statement that comes in, everybody doesn't get a hard statement anymore. Now they get it electronically. So it's important that you know that you want to put your assets in, or at least you want to put your passwords in a place where the person that you trust would be able to come and actually get access to your emails, your different Facebook accounts, or whatever it is that you have your assets, and so that people know what to do and where you have your things. Then you want to, you eventually need to open up an estate. If they're grown and they own real property, they own something, you want to get to the part of you actually opening up an estate and, itemizing what assets that person has. And once you know what assets that person has, then you go and you can file that inventory with the state. And then beyond that, then you start working down that line. They have deadlines that they create. They make sure that you get the inventory taken care of, and that that all your I's are dotted and T's are crossed within that. But I'd say the immediate thing is, first, just handle the mourning of this. There is no hurry, or at least it's not necessarily a hurry to get everything done and resolved.
Do you, this is just a personal question, do you recommend people purchase like their cemetery plots and do other pre-planning type things, or do you think it's better to wait? Or is that just
everybody's going to be different. Everybody's going to be different. If you personally, some people, you have a strong set of heirs or people that would be able to make your decisions for you, and that would be, comfortable doing that. Some people know, look, I've only got, one daughter, and it's going to break her up, and she's not going to be, she's not the type of person to do that. Well, in that case, maybe you want to take the reins and help her out. But if you know that you've got, if you know that you're able to, have somebody that can take care of it, I don't see that being a problem doing it. But I mean, you may want to just set it aside, have the conversation. So if that's going to be dependent on each individual person.
Okay. Well, that is all that I had for today. I typically go live for about 25 to 30 minutes. I said that I would give you guys about an hour today. It has. Well, it's 7:52, so we're 52 minutes. We've got about 8 minutes left. If anyone has any questions, we'll go ahead and take those. But if I don't see any within the next minute or so, because I know that there's a lag, I'll go ahead and end our session for today. Thank you, guys. I really appreciate everyone joining and always coming in and bringing your questions and talking to us. And I hope that this has been some really good information, because Erick typically charges for this seminar that he just gave to all of you for free. I know that when I go back and I look over, like 400 people go back and watch my videos. So that's a lot of money that he's given out for free. So I really hope you all appreciate that. And I truly appreciate it. Eric and I have been friends for a really, really long time. So we try to support each other in our businesses. Someone here said we'll be sharing with their mom. Awesome. That's good to know. Yeah, definitely. Especially I'm an only child. Most people that know me know that. So it's important, that my mom's stuff is in place. My daughter is an only child, so for me it's important for her, for me to have everything in place for her. Now that she's over the age of 21, it's a little bit easier, I believe. And I've added her to my accounts and things that she needs to know, she knows. But then Eric, it's a couple things that you said, so I need to go back and review some things. So we're going to be doing that.
And I guess that actually leads to an important one. Parents out there, people saying, should I add my child to the deed to my house in order to, as a plan? Because basically you're saying if I own the house, if I'm the only one on the deed, I'm the only one that owns it. If I add my child to this deed, now me and my child now own the house. Well, I mean, again, it's going to be it depends, because it depends. Is that child trustworthy enough to be able to make this addition? If that child is one that, financially is not sound, or makes, some poor decisions, like taking out a mortgage on the house, or would go to do something else fiscally irresponsible with some other aspect of their life, such that creditors are now coming to attach to any property that they own. It is real important that that you're mindful of that decision. I mean, I think there are definitely ways of transferring assets and making sure that your assets are taken care of without literally putting your child's name on your deeds and putting them on your accounts. And I guess the last piece of super free advice that is really important to share. Make sure that you really share this. This will save you so much time and energy and money. Hope you're ready.
Uh-oh. Do I need a pen and paper?
Yes, you do.
All right, I got my pen.
The most important piece of advice that I can give to anybody, the most important piece of advice I can give to anybody as it pertains to your estate plan, maybe, is to make sure that your accounts, any cash accounts that you have a beneficiary on those accounts, or at least payable upon death, or that there is some type of a joint owner to those accounts. Because one of the big problems that occurs is when you have your assets frozen because somebody passes away, all your assets are frozen, and so the bank will not allow anybody to come take those assets and transfer them until they have a court order by a judge, and they've gone through that probate process, and that takes a year at least.
Oh, wow.
Right? So it's going to be you're including into the cost of actually doing the work, the time it takes and the money and expense it takes to get that work done. But if you have a beneficiary, a beneficiary that is alive on your accounts, at least you can ensure that your assets are not frozen and that your cash accounts, I mean, that means that, you have a checking, savings, stocks, bonds, anything. Make sure that you have a live beneficiary, life insurance. Make sure you have a live beneficiary, and make sure that if you get divorced, that it's not your former spouse that's on those different accounts, right? I mean, you want to be mindful of that, because people, you create these accounts and you have your spouse as your payable on death, but that will occur even after a divorce. And so if you don't amend, you don't change, you absolutely will be giving your spouse those assets, and it's going to be tough to everybody else. I mean, without serious legal litigation expenses.
That's very true. Very good advice. I think people forget sometimes to update everything when they get divorced, and then you end up in situations like that where ex-spouses now control everything is part of your estate, or they've inherited everything, and your
Especially the
children
military
no longer.
guys.
Yeah.
Especially the military personnel, because when they go to serve and they go, when they go to serve, the they've got to create those different documents. And so if they don't adjust and amend those, they come back and live life, and then 30 years later, that's the only will that they've got. That's the only power of attorney they got, and these are the only wishes that they had. And it's gonna go how it is, how it was written.
Yes, it's so unfortunate, but this is why we're doing this session today, so that everyone can understand what they need to do, and to have in place to protect all of their personal as well as their business assets while you're living, as well as in your death. So again, thank you so much, Mr. Erick Tyrone of Tyrone Law Group. Will you share your phone number again one more time?
301-358-6664.
Awesome. Thank you so much. I appreciate everyone who has joined us, and I want to bid you guys a happy Sunday. And we will not be having a live session next week. I will be out of the country on vacation.
Because of her birthday.
It's my birthday
birthday
on Wednesday. My daughter's graduating from college on Friday, and we are flying to a wedding as soon as she runs across the stage and grabs her graduation certificate, and going to the airport because another friend is getting married in our destination. So we got to get there for the wedding. Hopefully there'll be no delays. And then we'll also be celebrating my daughter's birthday. She's a few days after me. So we got a big trip coming up. I'm super excited. So thank you again, guys, and enjoy your evening.